Hey everyone, welcome to the Darshan Talks podcast. I'm your host, Darshan Kulkarni. It's my mission to help you trust the products you depend on. As you may know, I'm an attorney, I'm a pharmacist, and I advise companies with FDA-regulated products. So if you think about drugs, wonder about medical devices, or even consider cannabis or obsess over pharmacy, this is the podcast for you. Do have to emphasize my guest and I are both lawyers, so this is not legal advice. I'm also a pharmacist. This is not clinical advice. I do these for educational reasons. So if you like these video podcasts, and I think they're a lot of fun, I find myself learning something new each time. So if you like something that you're listening to, please leave a comment, please subscribe. If you think people might learn something, please share. If you during the conversation you think that there's something interesting we discussed, please ask questions. We'd be happy to pull them in if we can. If you want to find me, you can always reach me on Darshan Talks on Twitter, or just go to our website at darshantalks.com. Our podcast today, our live stream today, is going to be about trademarking. Our guest is a partner at Duane Morris. She's the team lead for the firm's fashion, retail, consumer branded products industry focus group, and she's the vice chair of the firm's WINS program, which is the Women's Network program. She can be reached, and I want to point this out, she can be reached at ccampbell@duanemorris.com. Our guest for today, Christiane Campbell. Hey, Christiane, how are you?
Hello, I'm good. How are you?
Good to see you. Good to talk to you.
It always is. It's a pleasure.
Pleasure. So let's talk a little bit about things that are going on. One of the things that was really interesting to me before we start jumping in was you talking about how you're getting more involved in cannabis litigation, which I think is fascinating because as I was telling you right before we got on, you saw the odd cannabis litigation going on before, but everyone I'm talking to is talking about that right now. Is there a reason for the recent buzz, or go ahead?
I think it goes back to, and maybe kind of was accelerated by what we call the New Jersey effect. So the level of New Jersey's legalization really had an impact on not just the tri-state area, but the mid-Atlantic region. So in terms of legalization of cannabis, any given day, you look at the kind of the map of where you have some level of legal cannabis use, whether it's medical or recreational or both. The map originally kind of looked like a hamburger, where the legal areas were the buns, and then the middle of the country was really didn't have a whole lot. So you had like a very, very mature market in California, Oregon, Colorado, Washington, Nevada, and then you had Massachusetts, Florida, and then the East Coast kind of filling in. And when New Jersey came online, it really impacted New York, Connecticut, Pennsylvania. So I think what we're seeing is, and you and I have talked about this marching toward federal legalization, or so many different changes and filling in the middle of the United States where there will be some level of legality. And I think more and more companies, entrepreneurs, investors are recognizing that this is going in that direction. So getting into the cannabis space still feels, I think, early and new to a lot of people, but the market's getting more and more mature, especially in California. And I think it's a buzz that's going to continue to build until we get there. So I think that's probably partially behind the buzz. There's more and more in terms of, looking at federal legality being down the pike. And I think that's really legitimized. We have what we call the legacy market, which was kind of the underground and illegal. And there's more and more mainstream, probably because of the medical cannabis industry, mainstream uses that are becoming less, the stigma's going away a little bit, I think, in that.
That's kind of interesting the way you phrase that, which is you're talking about this anticipation that the rules are going to change. Have you, obviously there is a market sentiment that supports that. Have you seen anything that suggests from a legal perspective that's actually going to happen?
Yeah. The Farm Bill is one way.
Yeah.
Which is, it's old news now, but the Farm Bill is what really opened up the floodgates for so much CBD. Mm-hmm. Kind of, and there's talk of descheduling the marijuana aspect, and that would really make a lot of changes, because then you wouldn't have marijuana falling under the Controlled Substances Act. It wouldn't be a Schedule I drug. So although I have to say there is definitely a recognized need for there to be regulation. I mean, you have alcohol, tobacco, firearms, a lot of these types of things that have to be regulated from a federal level or at least a state level, and that's not going to go away. Nobody's saying let's just open the floodgates and everybody, it's a free for all. That's not going to happen. But so from a legal perspective, I think not necessarily starting with the Farm Bill, but that's something, at least in my world, with trademarks and branding, I really noticed made a significant change and really propelled the industry forward. It created a lot of snake oil and a lot of BS to wade through, I guess you could say, but has certainly changed the market, increased the number of products that are on the market, which heightens the need for branding and distinct branding.
It's interesting you mentioned this, the concept of snake oil and the concept of branding and how that's sort of all of it's coming together, because obviously branding plays a huge role in what people will buy and the impact thereof. Are you aware of the FDA's, and there's no reason for you to be, I just want to be clear, but are you aware of the FDA's recent guidance on intended use?
Well, I do know FDA is looking at CBD as potential drug, and therefore to the extent that it's being investigated for its drug benefits and its drug uses, it presents challenges for me, again, in my world with trademarks, because that means that your use of a trademark on a CBD product, because it's under investigation by the FDA, falls within the purview of the FDCA and makes it technically unlawful use if it's in general commerce. So that's kind of where the trademark and brand interplay is with the FDA and FDCA.
Yeah, the reason I'm saying this is the FDA came out with a recent guidance, literally, it's been in play for about 3 or 4 years. And the key piece that's come out, for those people who aren't aware, it's literally happened within the week. So for people who aren't aware, it's not like you've missed something huge. It's a huge thing, but it's one of those things that you'll see more come out as we continue. But the FDA definitely winked and nodded at the CBD and the cannabis industry in general, basically saying that you can't hide behind disclaimers and you can't hide behind saying things like, oh, not intended for drug use, but used for XYZ purposes. So what I expect as we continue is this idea of the FDA getting more and more into what claims are you making, and are these claims just within the state, in which case the FDA might say that we're going to practice jurisdictional discretion and enforcement discretion, if you will. Alternatively, if it starts crossing interstate lines, which a lot of these companies are thinking about and considering, as you're well aware, that's going to become a huge issue as we continue. So I guess my question for you is, do you advise companies in the cannabis space with that view in mind, or is that so unclear and murky right now that you're kind of going, look, let's start with the rules right now, work with that, and we'll have to keep adjusting as we continue?
A little bit of both. So, okay. On the branding side, branding is more than just picking a name and a logo. It's your colors, it's your packaging, everything about how you bring yourself to market, what you look like on a store shelf. Yeah. And at least in terms of packaging, the labeling is really important. So it is something that clients, they have to be aware of, familiar with, get guidance on, but also be prepared to be flexible. Different regulations, obviously it's the FDA, but every state has different guidelines and regs in terms of what your packaging has to say, what has to be on there. From again, trademark branding standpoint, with the labeling and contents and source and things like that is really important because of how much the CBD became so popular, especially. And you have a lot of mislabeling happening. I mean, trademark laws are in place for the purpose of consumer protection and anti-competition, or, preventing unfair competition. So when you have things like incorrect labeling, not only is that a consumer issue, from dosing standpoints. I mean, a lot of times you have in the pharmaceutical arena or the medical arena, you have doctors that are prescribing a certain amount of cannabis to a patient. And if the concentration is incorrect on a label, or if the dosing is incorrect and things like that. That's really a consumer issue as well. But some of the disputes over, packaging, labeling, concentration numbers and things like that are coming about in a false advertising, under false advertising theories, because you might have a company that is not really putting the resources into its concentrations and its actual product, but they're saying it's more concentrated than it is, or it has more of this or has less of that, or whatever it is. If that's not accurate, again, there's the consumer protection issue, but also it's false advertising.
So as a trademark lawyer, how often do you? So I'm going to try to phrase this properly. There are certain clients I've had who go, stay in your lane. I'm asking you to do this X job, work on this X job. And then there are other clients who go, no, I need you to point out things expansively that might impact. As a trademark lawyer, do you struggle with clients who are saying, I'm not asking you to tell me if my percentages are wrong. All I want from you is, does this label make sense? What is your perspective? How do you advise clients? Do you have trouble staying within the lane? I'll be honest, I tend to land up painting outside the lines every so often, if you will. But I'd be curious what your take is.
It depends on the client.
Yeah.
And a lot of times when a client tells me, I don't hear it often. I should say, if a client, in general terms, if a client says to a lawyer, stay in your lane, it usually means they don't want to pay for advice that falls outside of, the lawyer's area of expertise. I have to say, I think my clients and I are aligned. Every client's different. Every client's intentions, every client's goals with respect to market are different. And I pride myself in getting to know my clients very well and understanding what it is they need from me. If a client has internal marketing people, I'm certainly not going to step on toes. But if a client comes to me with an idea for a brand and they've asked me to clear it, if I only look at, what are the issues with respect to use of this brand and registration of this brand from an office standpoint, like, are they going to get an office action from the U.S. Patent and Trademark Office? If I only look at that and I don't tell the client, hey, this really may not sit well with a particular community or a group of people. If I don't advise them about potential PR issues, then I don't think I'm doing my job. I don't know that a client would, launch and then come back to me later and say, you didn't tell us that, Twitterverse was going to explode when we use this tagline or slogan because it offends, a certain group of people. But I don't think I'm doing my job if I say, yeah, you're clear for use and registration of this brand without considering the market aspects as well. If a client specifically says to me, our marketing people are looking at the ad copy for purposes of, marketing and claims, and if it's a social media launch, they're making sure everything has the sponsored and the right hashtags and all. If they tell me they're working on that, fine. But generally speaking, again, I like to take a holistic approach, and I don't think I'm doing my job if I tell a client, yeah, go ahead and use this brand because it's clear from a rote trademark standpoint. I think it needs to be, I need to be aligned and understand my client's goals. With scope of launch, I need to understand in what jurisdictions they're going to plan on using a particular mark. And it may be different jurisdiction to jurisdiction as to what sits well with the general public and what doesn't.
So let me pull you into a question that's very topical right now, which is this idea. I don't know do you know who Megan Rapinoe is?
Yes.
Okay. So she's considered a very woke individual, and she's currently, I believe, the face for Subway. And I just read yesterday's news, or I can't tell anymore because the days seem to all just come together. But within this week, apparently the Subway owners are saying that after the Olympics, they don't want Megan to be the face. I have no idea if that's accurate or not, but I just saw that name. And my question to you is, when you're clearing individuals, can you actually tie, when you get spokespeople, how, from a trademarking perspective, from a control of the look perspective, how do you do that in a way that's that doesn't come back to haunt you. And I'm thinking specifically of, I think it was the Verizon guy who then went out and worked for, I think it was T-Mobile. And I'm not getting the company perspective of this, but from an advice perspective, how do you ensure that A, you choose the right representatives, B, is there a trademark process associated with it, and C, how do you control that appropriately?
That's a really, really good question. There's a lot to unpack there. One, we always say I learn something new every time I do these. I did not know that Megan Rapinoe was doing Subway. That seems odd to me. But very topical. I do have a client that is, tends to be very trendy and is very much about staying up on the social media. They get involved in Twitter wars with their competitors and is an iconic global restaurant brand. So when they select people to partner with, if it's somebody that is so hot, trend-wise, whether it's in the music industry or sports athletes, we have to look at, and I rely very much on my team that's younger than I am, and that is very up on like the TikTok and the Instagram, and I follow who I follow, but like I find that I'm like years behind them on some of the things. We have to be really familiar with kind of the message and what content this particular celebrity or particular athlete, whatever it is putting out, and what they're really about and what their image says, because it might not fit with our client's brand. It might turn off certain of their loyal consumers that happen to be older or maybe younger, or there's so much that's important in terms of communicating, not creating the perception that, I know there's a number of brands that have done it, but, latch on to a particular individual or have certain policies that may offend others. I'm trying not to go too much into specifics because I don't want to,
Yeah.
But we do, from a trademark perspective, it's not so much the trademark from like the Lanham Act and the filing with the USPTO aspect. It's what's the client's brand about, and does this athlete or does this singer fit with their brand messaging? And sometimes the answer is no. And sometimes clients don't want to hear no because they really want to go after like the hottest rapper of that day, right, or the hottest TikToker of that day. And, they want what's hot, but I have to remind them you might spend a lot of money for this and it's not going to have a very long shelf life. Sometimes they don't care. But to have, the hottest athlete of the day endorsing your brand or working with you or partnering with you, 6 months after they've won a particular championship or something, it might get stale, and you've invested a lot. And how much bang are you getting for what you're investing in a particular celebrity? And then there's, you can't control what some of these celebs say on social media. So you really have to understand, what it is they're about. You can't have somebody that's going to be going off and dropping really foul language, representing a brand that is also, communicates with kids and younger generation. So
let's say you choose X athlete, right? My first question would be, when you're communicating with the athlete, going, look, I'd really like you to be to be our brand representative. But I don't want you to turn around tomorrow and be the representative for the next brand. I forget who it. Dave Chappelle actually said this. Like, I was watching one of his comedy shows. He's like, "Look, I was paid by both Coke and Pepsi, and recently I'm being paid by Pepsi. That's what I'm supporting right now. But that does not send out the message you wanted to send. So, as from a trademarking perspective, from a brand control perspective." Mm-hmm. As the lawyer, how do you go to a Dave Chappelle? And obviously, I don't know if you represent him or even anything associated with him. But how do you tell a Dave Chappelle who has his own sort of control, look, we can't have you do this? Like, do you do trainings? Do you have contracts in place? Like, what do you do to control this?
It's all about negotiating power. So first of all, you're never going to be talking to Dave or the athlete or the celebrity. It's always their people, You're talking to people. And they usually have... It's a sliding scale. The more celebrity and brand power celebrity power somebody has, the more negotiating leverage they have. So, Dave Chappelle obviously is very desirable. So if you're going to approach his people, probably comes with a pretty high price tag and a very, very little wiggle room in terms of negotiating his contract. And I don't want to say he's a loose cannon, but he may not be somebody who you can control or that you want to control. It would be, clauses in a contract that say, if you're endorsing this brand, you can't endorse these competitors, or you can't, and it's got to have a certain amount of time. A little bit you have to play to the emotion of the celebrity or their people and say, well, doesn't it look bad for them if they endorse Coke this week and then, 3 months later endorse Pepsi? They're going to start to look like they're a hired gun. There's other words for it, but they're going to start to look like a little bit of a sellout, like, oh, I'll take whatever, money from whomever. So not only is the branding disingenuous, because it's like, well, okay, it's kind of like influencers when they start to really, I don't want to say sell out, but they get big. It's like, wait a minute, they're losing a little bit of the personal touch that they had with what they were endorsing originally. Now they're being paid to do it. And I think consumers, the woke consumers, starting to recognize that. So, you're going to be talking to their people. You're going to be looking at a contract. You're going to want to have negotiating leverage. And the more desirable the celebrity, the less leverage you're going to have. And controlling what they do on Twitter, controlling what they say on Instagram, post on Instagram, it's virtually impossible. And the more control you try and exert, the less attractive you're going to be as a brand that they would endorse.
So let me ask you this question, as someone who's probably negotiated a lot of these contracts. So one of the most famous ones I live in a sad world where FDA is the coolest thing in the world, and I love reading about this stuff. But one of the coolest things that happened to us was Kim Kardashian was involved in a drug advertisement, and she said certain things, and turns out that what she said, and I expect it was thoroughly vetted, but turns out that what she said was not sufficient, was deemed to be false and misleading by the FDA. So she had to come back in and she had to do a corrective ad. My question for you is, when you're negotiating that contract with Kim Kardashian, I expect that you're negotiating the first one, saying that, look, we need you to do this and do this right, and we'll vet it and all that good stuff. If there's a situation where she has to effectively by law correct it, from a negotiating standpoint, do you kind of tell your client, look, I don't even think we need to pay her because she's required to do this according to the FDA? Or do you actually take the position that, no, she's a celebrity, you're going to get a lot of reach anyways, you might as well keep her happy? How do you sort of balance that weird dynamic where you're required to do it, but you're going to charge me $1 million? I have no idea what the numbers are, but $1 million to put this out otherwise. Could be right. So how do you manage that balance and sort of engage with her in an appropriate way?
Lawyer answer, but it depends. It's going to depend too on what side I'm on. If I'm representing the talent or if I'm representing the brand that needs the talent. I can tell you, having gone through that, your contracts from that point on, if you're on the brand side, are going to include a clause that says any corrective advertising is included here. And maybe, Kim's lawyers look at that and say, no, you can't have us on the hook for, what you call corrective, and it's actually just subsequent ads. So that's probably going to be a point of contention. But I think you're better positioned to have that buttoned up in a contractual arrangement at the beginning than have to argue about it later. If that makes sense.
That's so interesting.
Both sides.
No, of course. No, but that to me, if I was the lawyer for Kim, or the talent, as you put it, my first question is why are you expecting a problem? Like, why are we constructing the post-divorce?
That's when you throw the FDA under the bus. Yep, you throw the U.S. government under the bus.
So let's take that next thing. We talked a little bit about clearance searching, and you know what, we're kind of actually almost out of time. So let me ask you a general question. We're gonna have to come back to this because I know that there's a lot more to discuss here. We talked very briefly about clearance searching. So my question to you is, what is it? Why does it matter? and what's changed recently that people should probably keep an ear out for?
Okay. Clearance searching is something anytime a client comes to me and they want to launch a brand, they want to expand a brand, they want to protect a brand, I always recommend preliminary clearance and availability searching, because what it does is it gives us the closest thing a lawyer can get to a crystal ball. And it gives us an idea of, it's true. And I've told clients this, it's a crystal ball for, not that much money. On the front end, clearance and availability searching, it's what in the patent world they might call freedom to operate opinion, but that's effectively what we give. Really not that expensive. It's not that much of an investment when you consider getting involved in a trademark lawsuit in federal court, or even before the Trademark Trial Appeal Board, could potentially be in the hundreds of thousands of dollars or over $1 million, because you're dealing with discovery, you're dealing with experts, you're dealing with surveys, and it's just such a headache that could have been avoided. And I can tell you that in the whole freedom to operate type assessment letter that I give clients, I very rarely say no. It's really easy for me to say, oh, it's not available, there's this party and that party. The harder job, and when I'm doing my job, is when I tell a client, these are the risks. I'm hearing the client say to me, they want to move forward anyway. So my job then is to figure out how we mitigate those risks. So a clearance and availability search is not just to give a client a yes or no answer. It's to guide them and help them position themselves for growth, for an exit, for expansion geographically, expansion product lines. A lot of clients coming to me now, especially in the cannabis or alcohol space, will say, well, look, we're a one-trick pony right now, but our vision for our brand is to eventually evolve into a lifestyle brand. So I have to be looking beyond just the alcohol uses and the cannabis uses. I have to look beyond that and broader. And I have to look outside the United States as well, because so much commerce is done now internationally. So clearance and availability searching is one of the greatest value adds that a trademark lawyer can bring to a brand and a brand portfolio. Again, it saves you money in litigation, and it gives you kind of the closest thing you can get to a crystal ball and a clear path forward and a strategy. It helps inform a strategy in terms of brand protection and brand enforcement going forward. And what's changed is Trademark Modernization Act is coming down the pike. So that's really going to change how clients address office actions and use of actual marks. I lost your sound.
I just wanted to use that last bit to whet the appetite for the next conversation we're going to have. So stay tuned. We'll probably end up talking a little bit about clearance searching. I'll be honest, when we started talking earlier today, I 100% did not expect it to but we never know what these conversations are going to be like. But this was, as always, an amazing conversation. So I have 4 questions for you, as you know. So I'm going to ask them to you right now. The first one, based on what we've discussed, what would you like to ask the audience?
How many in the audience are actually involved in the practice of trademark law? I don't know if you can pull that, but yeah.
Well, let's find out. I am not. So we'll find out when that
That's
comes
why you call me.
Exactly right. So number 2, how can people reach you? It's on the screen, but
That's there.
But for those people who are just listening, I just want to. Would you like to repeat how people can reach you?
Yeah, I mean, my email is ccampbell@dwaynemorris.com, and I'm fairly active on LinkedIn as well. I try and post relevant articles. I do a little bit more, in terms of branding and its intersection with fashion, with luxury, and with cannabis on LinkedIn. And there's not that much of that content out there. So if you're interested in what's going on with like luxury cannabis brands, follow me on LinkedIn and get some information.
That sounds awesome. So that's 2. Number 3, what is something you've learned over the last month that people might be interested in, might be surprised to discover?
I've been saying it and shaking the trees for as long as I can remember, at least as long as I've been practicing trademark law as it relates to cannabis. But I keep hearing people say that they think that cannabis brands are not protectable and cannot be national because of the state-to-state regulatory framework. And that's wrong. So it's not something new to me, but it seems as though it's not a message that's really getting out there. So cannabis brands are protectable, and you are going to see, especially because of the increase in infused beverages, the increase in multi-state operators, we call them MSOs. You're going to see more and more cannabis brands becoming national and growing to national state. And I think it's really important for at least people interested in the space to understand that this is not going to be a siloed industry, I don't think, for much longer.
So is it fair to say that it'll be national, but you'll be doing it on a state-by-state basis? Or are you saying that you can actually register in the federal register, I guess?
Both. So we do a lot state by state when it's actually scheduled, technically unlawful product. If it's something that's federally lawful, for example, consultation services, website services, social media, we can get protection at a federal level. So when I'm talking to clients, I'm making a tiered strategy approach for them that takes, okay, what can we get you at the federal level? And what can't we get you at the federal level that we should, cover state-wise right now, and then eventually consider, expanding the protection to federal if possible.
So when you're doing, I'm sorry, I know I'm over, but I have to ask. When you're coming up with this state-by-state strategy, how do you decide? There are 50 states, and each one having a cost associated with them, so that gets expensive really quickly.
Yeah.
How do you advise clients on which states to start with? And does that, and then do you sort of just advise them on the risk that if we don't go to these other states, someone else may have priority? And how do you handle that?
That's a softball. That's a good one. The states actually answer that question for you, because unlike the federal trademark registry, the states do not have an intent to use basis to file. So in order to file a trademark for trademark protection in a particular state, you have to have used the mark in that state. So necessarily, you're only going to be able to file in the states where you've got actual product or services being rendered. Usually that's going to be the states where you've got a license. You're either operating or you got a license. So the MSOs are the clients that we're talking to, multi-state operators, where they might have that opportunity to file in multiple states. But a lot of clients are, kind of siloed state by state. So they're only able to file where they're actually operating, actually have product on the ground. And from a federal perspective, my advice is always, to the extent that we can get you federal protection for something, let's do it, to get you that presumption of ownership and validity nationwide that will gain you that priority that, waiting until you have use in a particular state might not get you.
I could keep going. Let me stop there. So interesting.
Another time.
Yeah, pretty much. My last question for you is, what was something that made you happy in the last week?
Do I have to limit it to one thing?
No, you can limit it to as many things as you want.
My son water skied for the first time. So that made me, I was screaming my head off. But right before we got on our call today, I hung up the phone with my team of lawyers and paralegals and assistants and docketing clerks and associates. And we've been on the phone for 2 hours. And, I hung up the phone and said to them, I know we're not together. I know we can't see one another, but it made me happy to tell them how happy I am with the work that they've done and the resiliency that they've showed and the efficiency that they've showed over the course of the last 18 months of being remote and not being together. So it was a 2-hour call, and yeah, it's a lot of work to do. It's a heavy lift on a lot of their parts, but it made me happy to be in the room, the virtual room with all of them, and feeling that teamwork and that the teamwork ethic. It just really made my day.
That's awesome. That's wonderful. So what we're going to do is we're going to have you back very soon. I hope you'll consider coming back. And this was wonderful. Thanks again.
Of course. Always.